So yes, the supremacy, secular character, whether it is separation of powers, and starting right from Keshwananda Bharti case, that is the bedrock here of the Indian Constitution also. Yes, it's very, very interesting. And the time which you are showing to us, it is really very interesting to see that, yes, when both the countries and the laws and the courts are in total consonance with each other, and can you be the latest judgments or these landmark things can be used in the courts, it will be very, very interesting. Yes. Indeed. Moving ahead, now I would like to just take you to the criminal side also, because we are basically keeping today's talk on two basic aspects, that is the Constitution and the criminal law. A similar chart, a similar type of interpretation, comparative analysis, I would also like to have that summarily and in broad traits, how different are the Indian and Canadian laws when it comes to the criminal law framework.
Absolutely. And I just would like to do a little disclaimer that I forgot to do initially very quickly, and I will do it showing you at the same time the Canadian Charter of Rights, the Hindi version of the Canadian Charter of Rights. Just so you know, everything that I say during this interview is not binding on the Public Prosecution Service of Canada, as you mentioned very generously and very kindly earlier, Professor Sharma. I'm a prosecutor in Canada, but everything that I say, I do say it on my personal behalf. Great. So when it comes to, let's first look at the similarities, and that will for those who studied criminal law, it will say, yeah, of course, both from our countries, but that's the purpose of it. If you conclude that, well, yeah, okay, it's the same. Yeah, that's exactly the point. It is the same, so that's the beauty of it. So the Indian Penal Code, I'm sorry, so is the universal criminal law. Yeah, it covers almost all the crimes, so et cetera, et cetera. So that's exactly the same in Canada. The criminal code covers almost all the crimes. So we do have, and the same applies in India, we do have a few other laws. I'm thinking, because that's my field of work, I'm thinking of the competition law, for example, Competition Act, I'm sorry. For example, that's not in the criminal code, but it does have criminal law provisions and criminal law punishment within the act. But most offenses, I would say more than 95%, are provided by the Canada Criminal Code, and the same with the Indian Penal Code. When it comes to the procedure, in India, you're lucky to have the Code of Criminal Procedure that provides the procedure for investigation of the crime. And I say you're lucky, why? And I can hear the students, they're not here this morning, but I can hear the students in my head, and I'm not schizophrenic, telling me, no, it's not a lock. We have that's way more to study. What are you talking about, Seb? It's having that in a code, it doesn't help. That's too much. Well, let me tell you, in Canada, unfortunately, it's a tad more complex, because the Criminal Code of Canada does include procedural rules. For example, the rules about the jurors, the procedural rule about thinking about section 650 about the linguistic rights in courts, also protected by the charter, but that's a different issue. But in Canada, and it is the case somehow in India as well, but there is no code of criminal procedure. So the procedure is still provided in the criminal code for not for the most part, but a lot. That's why I put it in the similarities between our countries. But common law decisions also provide plenty, an ocean of procedural criminal law principles that must be known by the criminal law practitioners. And that may sound strange for someone, which is not the case for Indians or Canadians mostly, but for someone who comes from Quebec, who is not trained in the common law system, For example, if we think of French people, German people, where things are legal elements are codified, you will not necessarily use spontaneously decisions of the courts to use basic practical and procedural law, whereas it is the case in Canada. Many principles are called by principles of the law that are decided only in decisions and not codified. But still, there's enough provided in the Canada Criminal Code to say it is a similarity, not identical, but similar. The third point, again, another point that may be taken for granted like democracy. The Indian judiciary is quite independent in India. It is also in Canada. And why did I put it there? So yeah, okay, yeah, judges are independent. What does it mean? There are more than 10, maybe 15 decisions of the Supreme Court of Canada that discussed the various aspects of there's the decision of the Queen, the older one that I may think of now, the decision of the Queen versus Valente, Valente, decided in the 80s of the 20th century. That is one of the first decisions post-charter to discuss the independence of the judges. And I know there are decisions as well, of course, rendered by the Supreme Court of India, also discussed the independence of judges. But why is it so important? And that's the same. In Canada, you can say judges are independent. They're not directly, openly influenced. Not saying there's no scandal, not saying there's no possible corruption. That's applicable for all countries in the world. So it's not the point, but we're talking about principles, important principles, core principles of both of our societies. And why is it so important? Because it is an element, in our modern times, it is an element of democracy. And if judges can be bought, as in some countries, unfortunately, can be bought by the accused, the legislative, the executive, by the power in place, by any whom, it doesn't matter. But it is a pillar of democracy to make sure the judges will be neutral, will not be biased, will be totally independent, will be skilled, will render justice. And democracy also involves a justice between quotes element. And that's why the independence of the judges, the judiciary, is so important. And in both our countries, and just the respect citizens, not only lawyers, but citizens have for the Supreme Court in both our countries. It is the respect of the law, the respect of, there's a decision. So we're neither India nor Canada are a rogue country where, yeah, courts decided this, who cares? This judge, I'll ask my dad who's the member of parliament to buy him, and that the case is gone. No worries. No. The law matters. The rule of law matters. Actually, justice must be and is served. So this is a fundamental principle. These are two things that are not only similar in our countries, but identical in terms of core principle. And the next one, which is quite interesting, I will not spend much time on this, but the existence of the mens rea, so for criminal offenses, the guilty mind. I put the Latin quote just for fun and just to tell a short story. When I was at the bar doing 2 weeks before my bar exam, one of the professors looked at us with a big smile, said an expression in Latin. We were 80 students in the room. And there was not this expression, but that was a very complicated Latin expression. He said, well, who knows here this expression in Latin? I raised my hand, I translated it, and right away, and I said, that means that, and this is why it applies in law. And I just wanted, I didn't want to show off or brag. I just wanted to show that I studied and I know my Latin expression in law. And the professor replied, thank you very much. You burst my bubble. I wanted to show you how ignorant you are, but seemingly you saved the honor of the students. So at the same time, of course, you don't necessarily to be a fluent Latin speaker to master the law, but Latin matters for sometimes for expressions. Just to give a little slice of life, if I may. I apologize for that, but I had to tell this story spontaneously, but that's a funny one. Anyway, so to go back to our to what we were saying about the guilty mind, the mens rea, criminal offenses, most of them have a guilty mind. In Canada, for example, what I can say is somebody who's a night walker, somnambule, somebody who doesn't have the intention of committing a crime, for example, wakes up in the middle of the night. He doesn't wake up actually, and then he beat up somebody being asleep. So that could be a defense, even though he doesn't realize because he's not conscious of his actions. That's a stupid example. Actually, I apologize, but let's take another example. Somebody who's under the effect of alcohol or drugs, not necessarily voluntarily, somebody who is drugged by someone else in a bar, for example, who's going for a drink, or to a restaurant, not necessarily drinking wine or beer, whatever, but just enjoying a meal. Drugs is placed in the meal. The person is not behaving in a normal fashion. And then this person starts committing crimes, for example, doing mischief, destroying everything in the restaurant. But this person is known to be a peaceful person, never have done anything wrong in his or her life before. Well, that could be a defense, a criminal law defense. I'm not going to enter into the specific aspects of it. But if the person, in that context, the example I just gave, is not aware of, not conscious of his or her own actions, it may say, well, yes, the actus reus, the act itself, actus reus, the Latin expression, but the actus reus is done. There was a mischief in the restaurant. Mr. Seb, for example, destroyed 4 tables with his fist and the plates, etc. But he was not, the defense could potentially be, not necessarily, but potentially be, well, Mr. Seb, myself, was not conscious of it. He was under the effect of drugs. So that's very important in the criminal law. And also that's similar between our countries. There's a few distinctions, but also there are similarities in the details, because we all know the devil is in the details, even though all of us are angels, but the devil is in the details, like they say in English. So there are exceptions. There are exceptions, also similar exceptions as applied in Indian criminal law and Canadian criminal law. So we do have the absolute liability offense, the strict liability offense, as opposed to the mens rea offense. So there are offenses where somebody in Canada, let's take an example, where somebody may be, or when I say somebody, a business, a corporation may also be a person. That's another debate. That's quite an interesting debate, but for another time. But also there are offenses where you just need to do the act and you're guilty. I think of the example of a corporation that pollutes a river, the business pours chemicals in the river, pollutes the river. There's evidence that the business did that. Well, in those cases, I know it seems to speak about environmental law, but it may also be a criminal regulatory offense. So in that context, for example, do you need to prove that the business is aware? Of course, business corporations don't. We're not going to enter into these details, but there's the piercing of the corporate veil that applies in those cases. So you basically go to the president or the leading spirit, the corporate mind, personified by a person to prosecute that person. You can also prosecute the business, but let's put that aside. It's too complicated for this interview. But what I would like you to keep in mind is the exceptions are, and the same applies in India. You don't necessarily need to prove the guilty mind in some cases. And there are categories it's been a while ago that's been categorized by the Supreme Court of Canada in Sault Ste. Marie. That's the decision that's in the slide in 1978, yes. And there are 3 categories. I will not this morning enter into the distinctions between these categories, but just be aware that we do have this similarity as well. And of course, it triggers several issues. The same issues, as I know, are also triggered in Indian law. So in Indian law, for example, as that it shows, the Indian Penal Code itself, so it says there, I took that from a text, but there are plenty of other examples. So there are offenses of strict liability, the same as in Canada. So you just need to do the actus reus, so section 292 of the Indian Penal Code, so regarding the selling, hiring, distributing the obscene books. So that section is a strict liability offense. So there's no need for proving for the prosecution or the Crown Counsel, as we call them in Canada. There's no need to prove the guilty mind. Just the action is sufficient. Of course, there are some nuances, some distinctions, etc., some peculiarities and specificities, but in the great scheme of things, we do share these things. So that's the beauty of it. So not only can we compare between India and Canada, the core, important, fundamental constitutional principles, but also when we go more specifically in other fields, specific fields like criminal law, we do have similarities. Again, why? Well, we are long-lost siblings, but a family waiting, anxiously waiting to be reunited.
Yes, that was really a comparative analysis, but yes, I can see that similarities, I can see more than the dissimilarities here, as you told. And most of the things, actually, the background is the same, the backdrops are the same, right? And of course, the mens rea here in India forms a major part of the journey of the accused from the commission of the offense till the time he is convicted or acquitted. So it forms the bedrock of any of the judgment here in India. So actus non facit rem nisi mens cetri, as you said, it rightly applicable in our context also. But yes, I can see the strict liability offense or the absolute liability offense for the Canada Criminal Code also quite relevant there, right? So yeah. So with this background, it was really an honor here, and I can see that lots of questions that you've given us some food for thought for the viewers here, for the audience here. So many more questions will be coming after going through your presentation by the students, which I'll be posting you soon, Seb, through emails and others. So in some next series of such interviews, we can clarify those questions also, right? As well, we can go into some more technicalities of the issue, as you said that everything cannot be discussed here in just 30 minutes discussion. So I would just like to say any of your last thoughts now. Your last thoughts.
Oh, yeah. So, yeah, just two differences very briefly. There are two main differences between our criminal laws, and they should be kept in mind. And the first one is the death penalty. It was repealed in Canada in the 70s of the 20th century, so it doesn't exist anymore in Canada. But why is it so interesting? Why the differences here are interesting? Well, the death penalty was discussed by the Supreme Court of India several times, including very recently. So this is a topic that is quite interesting. To keep in mind, it's an ongoing debate. India is not the only country that has death penalty. Of course, some states, not the United States, the entirety of the country, but some states in the United States still has death penalty as a punishment.
Yes.
Other countries in Asia, like Vietnam, has death penalty. It has a completely different political regime than India, but several countries has it, but Canada does not. And so the debate is quite interesting to be had eventually. The issue of bail. Bail is what? Is one, summarily, it's the release of an accused person. But, and as I pointed out, actually, with Professor Kagesh Gautam, who's a professor at Jindal Global University in India, so we did commit a crime, which was to co-write, add a lot of intellectual fun to co-write a piece together on bail between India and Canada. And what is stated in that book chapter is there are extremely important lessons to be learned from Canadian law, but vice versa, obviously. But one of the few differences is the existence of anticipatory bail. That it's unique. That this is a unique thing in the common law world, at least the Commonwealth countries. So basically, somebody who is arrested in advance. I'm not laughing, but it's a bit, for a Canadian mind, it's very difficult to understand as a concept. And I had plenty of discussions with Professor Gautam about this. But this is when somebody a person is arrested before being apprehended. And it is quite interesting as a concept. But also the burden of the evidence, that's something else. The burden of proof, I'm sorry, is different. In those cases in Canada, that will not happen because in the cases of anticipatory bail, the burden of proof is on the accused. Also, the other distinction when it comes to bail is the bailable offenses or non-bailable offenses as they are categorized in India. There's not such a thing in Canada. Canada, we do have 3 grounds, non-cumulative, for which a person may be released. So if summarily, very briefly, if a person is not a risk, and is not in risk to not attend court, so if the person is not fleeing court attendance, if the person is not substantially likely to commit a crime, or if it doesn't put the administration of justice into disrepute. So in those 3 cases, if everything is fine, if there's no possibility that a person will flee justice, if a person is not going to commit, they're likely going to commit, substantially likely to commit a crime again, or if there is no possibility to put the administration of justice into disrepute, then the person may be released. So it's a totally different way of approaching bail, but the grounds is the same. The ground is, should a person be released or not? In other countries, it's, again, what I found, to finish that on that note, is what I found beautiful, sincerely beautiful, as art. It is the fact that both our laws were the sons and the daughters of the United Kingdom because of our legacy. But we cherish also our distinctions. We are not under the rule of the United Kingdom anymore, both Canada and India. But we share the common law. We share different principles. We share the principle of bail, for example. We share that, but we interpreted and applied it totally differently. So the beauty of it is in the difference, in the differences here. And this is why it is instructive to see how different India and Canada are as well. Not only to see, to comfort ourselves and say, oh, we're so similar, That's right, Seb. We should be together and agree on everything. It is not what I'm saying. We don't need to agree, but to evolve intellectually. But knowing the differences, it's enriching for our minds and our soul, and of course our brain when we think about how the law should evolve. Thank you very much. Oh, I do not hear you, Professor Sharma.
Yes, so the anticipatory bail particularly, which you mentioned, yes, it forms the main right of the accused person, right? That yes, he has the right of anticipatory bail to apply for a bail in anticipation, which is not the case in your country, I guess. And you were, I could see you grasping with that anticipatory part here, some of the differences. But yes, every coin, I guess, has two sides. So are the laws here. So they are the facets of the same coin, but I guess.
Yes.
Right. So it is very, very, yes, it was very, very interesting to see both the laws, constitutional as well as criminal laws. And with this wonderful dhanyavad on your part. So I would just, at the end, I would like to listen this thank you in Hindi from your mouth, Mr. Professor Sébastien.
Oh my God. Davyanad, is that it? No, I'm sorry, I screwed it up.
Yes, it's dhanyavad, yes. So thank you so much.
Dhanyavad, dhanyavad, sorry, yes.
Yes, so thank you so much for this wonderful interaction, Sébastien. See you, I would like to have many more such interactions with you on different topics, comparing both the laws. So once again, thank you so much.
It was a sincere pleasure, and I thank you very much, Professor Sharma, for this great invitation. It was honestly a great honor, and let's keep Canada and India together.
Thank you. Thank you so much. I thank you on behalf of Shoolini University, also School of Law, our Vice Chancellor, Professor P.K. Khosla, Pro Vice Chancellor, Professor Atul Khosla. Thank you so much on their behalf and from all the entire students and staff of School of Law at Shoolini. Thank you.
Thank you.